Hi, welcome to the Race, Gender, and the Right to Bear Arms panel. We're going to get started. Before we do, just wanted to do a little housekeeping. For those trying to receive CLE for this program, you've already gone through this drill. You'll need to submit 2 codes, which will be provided once in the middle and once closer towards the end. I'll read those codes out to you at the appropriate time. Okay. So the panel is Race, Gender, and the Right to Bear Arms. Personally, I find this quite interesting because I think especially for progressive constitutionalists or that type of project, I think it exposes some intra-partisan divisions. I think it tests multiple commitments that progressives have to particular constitutional values. And I think our panel today is going to bring that out. So let me begin by introducing our panelists, and then I'll have them speak for about 5 minutes each, and then we'll start a conversation amongst the panelists, and then we'll open it for questions from the audience. So to my far left, your far right, is Esther Sanchez Gomez. Esther is the litigation director at the Giffords Law Center, a nonprofit legal and policy organization working to end gun violence. Before joining the Giffords Law Center, Esther was an associate with Brian Cave and clerk for the Honorable Rosemary Marquez for the U.S. District Court for the District of Arizona. She has a chemistry degree and a law degree from the University of Arizona. In the middle, you can clap. In the middle, we have Christopher Smith. Christopher is the early defense supervising attorney with the Bronx Defenders in New York, where he served since 2017. From 2022 to 2023, he served on the George Floyd Litigation Task Force Fellow with the National Lawyers Guild. Christopher has also co-authored 2 amicus briefs, one in Bruin, the other in pending case Rahimi, in support of the challengers to those gun regulations. He's written on the intersection of Bruin with policing on black and brown communities, and his writing has appeared in the Washington Post SCOTUS blog, amongst other publications. To my immediate left is Amber Goodwin. Amber is the founder of Community Justice, it's a nonprofit, and an ADA, an assistant district attorney in Travis County, Texas. Community Justice is the only black and brown-led national gun violence policy organization with a focus on building power for and with communities of color to end gun violence. As an ADA, Amber has worked with the Special Victims Unit and the Pre-Trial Diversion Unit as the liaison to the City of Austin Community Violence Ecosystem Partners, and was the chair of the Gun Violence Task Force. In 2020, Amber was appointed by then President-elect Biden to run his presidential transition as the lead staffer overseeing all gun violence prevention efforts, and her writing on gun violence prevention has been featured in several publications, including the New York Times, Forbes, the Yale Journal of Law and Medicine and Ethics. Prior to working at Community Justice, Amber worked at Giffords and spent 23 years working on progressive issues across the country. So those are our panelists. Please Amber. Okay. So we're going to go in the order that we're sitting. So Esther, then Christopher, and Amber. I'm going to have Esther start us off with some remarks about, based, I think, partly on the Giffords Center's briefs in Rahimi and Bruin, and her general perspective on the issues of this panel.
Thanks, everyone. Can you hear me? Do I need to be? Okay, great. Well, thanks so much for having me. I think this is a really important issue, and I think there's a lot of sort of good faith perspectives trying to approach what is clearly a harm that our society is experiencing. So I'm really excited to engage in this conversation. Since we're talking about the Second Amendment, and I'm going first, I guess I'll start with some background about the Second Amendment. So the Second Amendment, and there's going to be a reason that I'm talking about history that we'll get to, but the Second Amendment was ratified in 1791 and incorporated against the states using the 14th Amendment in 1868. And I think it's worth mentioning also the 19th Amendment ratified in 1920. This is the first time the Supreme Court recognized an individual right associated with the Second Amendment was in 2008. So we have a long history leading up to the first time we're talking about any sort of individual right with the Second Amendment to begin with. I like to say that it sprung out of the ground in a lot of ways in 2008. And specifically, that right is tied to the idea of self-defense, individual self-defense. And in 2008, that was announced with regard to the home. So you have a right to be in your home with a gun, to act in self-defense. In 2010, it was basically acknowledged that it was incorporated against the states using the 14th Amendment. And then it was extended into the public sphere in 2022 in Bruin, which is the case that I think my colleagues are going to talk about and that was introduced at the beginning. Bruin was the first time that the Supreme Court really took up substantive Second Amendment issues since the first time it announced that the Second Amendment had anything to do with an individual right. And it really changed the playing field in the way that we think about the Second Amendment by shifting the way that we consider challenges under the Second Amendment from the way that we think about constitutional challenges generally, means and scrutiny, to a history-focused approach, which is something that the Supreme Court has been doing in a lot of different areas, but really sort of shifting our focus to considering whether our history and tradition supports the existence of a future-looking law as opposed to whether that law is tied to the goals that it announces. I want to pause on the idea of self-defense and sort of level set with some empirics. Guns are rarely used successfully in self-defense. I think it's in less than 1% of crimes that guns are used successfully in self-defense, and actually guns increase your chance of harm and death when they are involved in a crime. So if you are carrying a gun, you're less likely to be safe if you're carrying a gun experiencing a crime than if you don't have a gun. Homes with guns are also less safe. Studies are consistently confirming that possession, ownership, and use of guns are associated with increased risk of injury and death if you have a gun in your home. So when we talk about a right to self-defense with a gun, we're sort of starting with a false premise. And I think it's worth remembering that as we talk through this. I think it's also worth remembering that our common law system protects a right to use deadly force in certain circumstances. And by extending that right into the public sphere, which is what the Supreme Court did in Bruin, it really upset the balance that is struck by the common law requirement to retreat if you're not in your home. So we're really at the intersection of a lot of different areas of law and a lot of sort of false assumptions about the facts of using guns. But what I want to talk about sort of more specifically is that the harms of having guns in public spaces and broad Second Amendment rights are not just physical. It's not just that 45,000 people died last year by guns in this country. It's that the individual exercise of these rights is actually causing harms to democratic institutions and processes in our society. Our rights, when we think about the Second Amendment right, does not self-reinforce with other constitutional rights that we oftentimes think are important to our democracy. And I think that that's contradictory to the way that we think about other rights. So we can think about our right to assemble or the right to free press as sort of reinforcing our right to vote, right? But I think that when we talk about the Second Amendment, we actually need to be talking about those as separate and as zero-sum. The right to have a gun in public spaces can expand beyond those other rights and ultimately engulf them. Not everyone enjoys rights equally in our society. So when we think about a public sphere that's full of guns, certain people are no longer going to be able to access that public sphere, to speak freely, to access their polling places if there are a lot of guns in public spaces. And I think that that's an important piece of the harm that we're experiencing as a result of expanded Second Amendment rights. And as usual, the people who are suffering those exclusions are the people who have historically always been excluded. And I think that that's a good transition to talk about Rahimi. We're obviously going to be talking about race in this panel, and that's a hugely important piece of this conversation. Rahimi, which is the case currently pending before the Supreme Court, is a case dealing with the federal law that prohibits people subject to domestic violence restraining orders from possessing guns. Domestic violence, by and large, affects women, and so when we're talking about it in the context of Rahimi, what we're talking about is women's access to democratic processes. So I want to say that, the Supreme Court, this is the first time that the Supreme Court is taking up this issue and applying its new history-focused test that it announced in 2022. In the wake of the 2022 Bruin decision, the lower courts have been pretty much in chaos considering how to apply this history-focused test. What does it mean? What history do we look to? How do we as judges act as historians? And how much of a history is necessary to satisfy the requirement of this law being analogous to our history and tradition of regulating firearms? Those are open-ended questions. Courts across the country have reached very, very different results. And so this is the first time the Supreme Court is going to give us any instruction, and it's going to be incredibly impactful for what gun regulation looks like going forward. So how do we look to how do we look to history to protect people who are not part of the people in the time when these laws were being passed? So I think it's, when we talk about a history-focused test, what we're talking about is looking to people in the past and the laws that they might have or would have passed. But if women were not part of the people then, or black people were not part of the people then, so how are we really considering a democratic process going forward? Essentially, we're silencing those people by looking past, basically limiting democratic processes going forward. And so I think sort of my central point here is that the Constitution needs to be read as a whole, taking into account all of the rights that we are trying to exercise, and noting that the Second Amendment can actually reduce our access to those other rights. And if we continue to look to the past in order to consider how to expand and protect rights going forward, we're going to be ending up in a less equitable society. The Supreme Court likes to say that the Second Amendment is a second-class right, and I think that in some ways it needs to be if we think that our access to First Amendment, for example, rights, or 19th Amendment rights, or 15th Amendment rights should be protected, then it needs to be second-class because it is ultimately zero-sum. And I think that that's sort of where I'll take us and pass it to my co-panelists.
Great. Thank you so much. Christopher.
Yes, hi, very happy to be here. Christopher Smith. I was born in the Bronx, live in the Bronx, and I work in the Bronx as a public defender. Congrats. And I almost fell into all of this by accident, I guess. Maybe accident is a strong word. But I was on vacation visiting a family member in Texas, and I just so happened to visit a gun range. It was my first time shooting a gun, and me and the person I was with, we shot all sorts of things that I've never seen in my entire life. There was a .45 caliber Desert Eagle, an AR-15, and even a semi-automatic shotgun, which, that is as destructive as it sounds. And all of that was available for less than what I paid in rent monthly, right? Leave the parking lot, I see all these bumper stickers saying, come and take it, it's my Second Amendment right, etc. So I was very much in an environment that not only gun possession was allowed, it was pretty much encouraged, right? And guess what? It was also a predominantly white location, right? At the same time, not at the same time, when I'm flying back, I get a response from a DA where I was trying to get a non-jail offer on a young kid I was representing. He was like 18 or 19 at the time. And it just lit something in me. It's like, how is it that I am in this white neighborhood and gun possession is encouraged, and at the same time I got this kid in the Bronx, literally, we're talking about a 9mm, right? The overwhelming majority of cases that I deal with, we're talking about 9mm small handguns, right? And this DA is telling me that this kid has to go to jail, and particularly 3 years upstate. Now, I don't know how familiar this room is with upstate incarceration, prison incarceration, but for a 19-year-old, that will have lifelong consequences, right? He will be a felon for the rest of his life. Recently, I was in a room with these exonerated folks, and the common theme, of course, aside from the message and the fact that everybody was formerly incarcerated, was that everybody had some sort of physical disability in some way. This person had a cane, this person had a hearing aid, and it was just another one of those markers that this is what prison does to people. So I came back to New York very angry. I was talking to anybody that would listen and say, how is this fair? How is it that the Second Amendment is a right that only exists for some, and for us in the Bronx, it means mass incarceration? So from there, got connected, spoke to a couple of my other coworkers, which also assisted in the Bruin brief, Michael Thomas and Amy Carlisle, which is no longer in the office. and a former colleague, Avi Samarth, and there's like, hey, there's this brewing case coming. Why don't we just do an amicus brief? So we agreed that that was the path we should go. There was a lot of discussion, a lot of politics around the office. Everyone in management was debating whether this is something we should do, whether it was a good idea. And it turns out we kicked the hornet's nest. We're getting calls left and right from people saying, this is not a good idea, don't do it. You're gonna hurt our cause, this is not what liberals do. And we ignored all that. And we asked around the office, can you send us some stories about gun cases? And we chose 10 across practices that highlight different impacts that gun prosecution has. And we put it together in an amicus brief. And yes, we do talk some law in that brief. We do highlight the racist history around the Second Amendment. But really the intent behind that brief was to highlight the client's stories, right? And I do think that that's a point that often gets overlooked when people talk about our brief. We get called, that we're going to be used as a tool by the right to support pro-gun legislation, that we are, in fact, pushing anti-black solutions, et cetera. And the point is, this is what's actually happening to the people I represent on a day-in, day-out basis, right? Yes, I politically identify on the left, or whatever moniker you want to put on it. But this reality, if it's inconvenient, then so be it, because people's lives are being derailed. Anytime someone picks up a gun case in the Bronx, we are talking felony charges, felony violent charges, and DAs are very unlikely to come off those offers. Yes, there are diversion programs, but in my experience, I do think that that is actually the political cover to say that, no, this is not mass incarceration. It's few and far between the clients that actually do get to take advantage of those jail diversion programs. Most of the times, the offer is upstate jail. As a matter of fact, I took, I believe, 3 or 4 pleas in the last month that included upstate time. So I do very much think that the racist past of this country and the disproportionate right of who gets to actually hold a gun is seen very much in the Bronx. And I guess the closing message to everyone here is, A, if you do see racism and inequities in your profession or in your life, I do think that we all benefit by shedding light on it, right? And I knew very little about amicus briefs before brewing, right? It was a very quick turnaround. I think we wrote that whole thing in a week and sent it, and did not, ask these broader questions about what it means. We dealt with a lot of that after the fact. But hey, once you're a barred attorney, you can get admitted to the Supreme Court and file amicus briefs, and I strongly encourage everyone here to highlight the racism that you see in the profession.
Before I move to Amber, I just want to say that with the first 2 panelists, I think it sort of joins the real tension that we have for this panel, right? Men of color, as I understand it, half as likely to own guns as white men, but they are significantly more likely to die of gun violence and overwhelmingly bear the brunt of prosecution, as Christopher was saying. But as Esther has told us, American women face higher rates of lethal gun violence than women in many other high-income countries, with black women being significantly more likely to face that violence. And so already we have sort of the tensions, the intra-ideological tensions here for progressive constitutionalism and gun rights. With that, I want to turn to Amber, whose experience both as a prosecutor and as somebody who works with community organizations, I think is going to be useful to us and may help us think about this problem beyond just the legal questions that the Second Amendment presents.
Yeah, thank you so much. I was telling one of my friends that I was coming here today to talk about race and guns. They were like, it's like my Super Bowl, right? Of getting to actually talk to people who care about issues like this. I'm Amber. I am very privileged to get to work as a assistant district attorney, but I'm going to talk first kind of on wearing my hat as the founder of a gun violence prevention organization. And so just by way of background, I started community justice because what we saw, and many of us, including my colleagues who work at Giffords and Everytown, so many different people, we saw the need for really a political and policy home that was led by and for Black and brown people, people who had traditionally been left out of the conversation on gun violence. And what I will say is that when I started working on gun violence, which I just have such a huge amount of respect for Gabby Giffords, my eyes were open because I didn't know what a gun magazine is, and I'm from Texas. And so I had no idea what a gun was. And so but that's a lot of privilege, right? To go through, at the time, 30 some odd years of not knowing anything really about guns, but then getting the privilege to work for this amazing person. But what I saw was how the rooms were opened up, whether it was the White House or whoever was opened up because we had access to this incredible organization and incredible leaders. But when I walked into these rooms, I was the only Black person, I was the only woman, and it didn't sit right with me. And so started this organization, again, in partnership with so many other people. But I also started doing a lot of research, and I was like, let me just look into this Second Amendment that everyone is talking about. And I wasn't a lawyer when I started. I went to law school. I became a lawyer at 42, which was years ago. And so I became a lawyer later in life. And so I was going to start, I had some remarks here, and I was going to start back in 1871 whenever the NRA was started. I will not take us back that far, but what I will say is race and guns is in the fabric of this country. And I think there is no ideological difference between anybody, and if anybody wants to argue with us or anybody in the room about that, about why these structures were started, who do we all think set up a system to where Black and brown people, or low-income people, even if they wanted to have access to firearms, cannot get access to firearms when we're shot and killed, whether it be by police violence or by stand your ground laws. We are not protected the same way that white people are, especially white men. And so I think the question that many of us who work on either Second Amendment or work on guns and laws really, I don't think it's a struggle, but I think we need to be very clear about is that when we are talking about the Second Amendment, and when we have been talking about the Second Amendment for so long in this country, we are talking about white men with guns, period. And so I think people, and I'm glad that Esther already brought it up, of we need to separate that out from who we're actually talking about and whose rights we're actually protecting, because it's extremely important that we not only think about what's happening, what I would consider downstream of who's being impacted by the Second Amendment laws. And we know, and I know, and all of us know from working on gun violence, that when we're talking not just about gun laws on the Second Amendment, but we're talking about background checks, things like that, we have to really think hard about who's going to be impacted by these laws, and whether or not that is, adding someone to a prohibited purchaser list. For many of us in the gun violence movement, that was the jam, man. We were background checks or bust for such a long time, but when we started to question, many of us, what happens to the people who are added to that list? Who is going to be automatically added to that list? Who potentially is not going to be able to take their name off of a list because of their last name will automatically put them on some sort of banned list. I will just say it was very much a struggle, because for such a long time in this country, we have been conditioned to think that this is the way that we talk about guns, and we only talk about responsible gun ownership. And I still cringe, and it's still in my kind of lexicon of saying, we're all just talking about common sense gun regulations. And I'm like, y'all are talking about white men that have common sense that are using their firearms. You are not talking about, Philando Castile. You're not talking about these Black and brown people who have been impacted. And so I say all that wearing my community justice hat of being an advocate, of talking about the work. But, I think when we're talking about the Second Amendment and even all of the most recent cases, it's very focused in its text on obviously historical nature of gun regulation, but also on regulating firearms. And so when we say the right to bear arms and we're talking about gun rights and different things like that, it is a very specific part of the text that we're talking about, and not all rights of having a gun, who can have it. We're not talking about every single piece going upstream on gun, because the Second Amendment isn't talking about making sure that there's a right to not have guns trafficked in our community, right? The Second Amendment is not talking about the public health crisis of gun violence, which is part of the foundation of this country. And so I think because the Second Amendment, even looking at the Declaration of Independence, there was a Black trans activist in in Canada who I at least recently was listening to, and she was talking about how in America we say life, liberty, and pursuit of happiness, or life, liberty, and that's what everybody wants, right? We're supposed to have in the United States, but for the most part, Black people we're still working on life. We're still back here working on life. We can say, those of us with privilege, that we were trying to get this pursuit of happiness, but for people who look like me, and I'm so glad that we also brought up women who were disproportionately impacted, especially by what's happening with Rahimi. So the work that we do in Giffords and so many other organizations is really focused on these public health approaches to gun violence that look at gun violence as the public health crisis that it is, and find solutions that don't have due process issues, that don't threaten the Second Amendment. And we've been able to have a lot of bipartisan support with these strategies that really target the people who are at the highest risk of either being shot themselves or having somebody shoot them. I will say, as a prosecutor who works or worked for a long time into the Special Victims Unit and that lives in Texas, when I hear people say gun laws, I'm like, what does that mean? I'm in Texas. There are no gun laws, and there's very different gun laws talking about felony stuff, and so this is life or death, right? As someone who there's a challenge of getting the protective order. So for us, it was like for what is happening, and I'll just keep this very broad. We signed on to an amicus with other prosecutors' offices from varying degrees of the sides of the aisle across Texas, because it was so critical and important that we were all on the same page about what would happen if these protective orders, if this firearm removal would not be able to happen. We already have challenges and are working through some with the federal government and some with other protocols. We're working through things like firearm surrender protocols, but part of that is like looking at the text and making sure that it's regulated the same as the state law in Texas, and then thinking about what's going to happen with Rahimi. And so for those of us that are in the Fifth Circuit, or that have been, right now we have good law in Texas that we can actually follow, and so Rahimi hasn't changed what we're doing because we're following the law in Texas, but it is something that is extremely critical for us to really examine, because as Esther and Chris both said, they weren't thinking about us whenever the Second Amendment was founded, and also I don't know if they were thinking about us a couple years ago, right? And so I think that it's important and critical that the people who don't have the privileges that I think all of us have of being lawyers, and that we're asking these provocative questions about how do we poke holes in something that has been such a part of the fabric of this country, to have the right to bear arms, because it makes a lot of people uncomfortable, especially in Texas. I'm surprised you didn't get a gun whenever you walked off the plane, but that's part of it, not just Texas, but other places as well. And so, but that's, I just want to stress especially the urgency of what would happen and will happen to women and low-income people due to the Rahimi decision too.
Okay, so I'm going to just one housekeeping note. So for those who need the CLE code, the first code is Fox Theater. That's 2 words. Fox Theater. Okay. By the way, I'm going to pose some questions to the panelists. Suppose I should say, so you don't think I just walked up and started moderating this panel with no background in this. I teach constitutional law at University of Colorado with a focus on Second Amendment concerns. And so with that background, I wanted a first question for Esther and Christopher, and then I'll come to Amber. Esther, actually you and Amber both noted a history of gun regulation, a history-focused methodology that the Supreme Court is using, and both of you noted that at the time of the ratification of the Second Amendment and the creation of many of the initial laws or non-regulation of firearms, that the people who would have been voting or have some stake in it would not have been the people that we're talking about today. It's a methodological point, well taken. Unclear whether there's 5 votes on the Supreme Court tomorrow if Rahimi were to come down next week to actually reconsider that. So what I want to ask you, Esther, is how should we think about and incorporate the very important concerns that Christopher is articulating in advocacy around the Second Amendment? How can we protect the over-prosecution of Black and brown communities while still advocating for protective gun laws that are going to protect the public sphere?
I think that's an important question, and I will say I don't think that there are 5 votes to reconsider the history-focused approach, so don't come to me if that doesn't happen. It won't. So I think that an important piece, Amber touched on this as well, I think that the reality of the Second Amendment is that not everyone enjoys expanded Second Amendment rights equally. And I think that a lot of times when we're talking about issues involving, racism in the criminal justice system, the rights that we need to be focusing on, in addition to reducing violence in our communities, are access to equal protection under the laws, right? Due process. And I think that we need to be addressing those in parallel, and not, focusing on one over the other. I think that broadened Second Amendment rights are ultimately going to subordinate those rights. And I think that that's an important practical consideration. If everyone has a right to have a gun, that doesn't mean that Black people will immediately be able to exist in spaces with guns safely. That's just not the world we live in. And so I think to start from a premise of we need to expand this right in theory because it will expand the right for everyone is a false premise. And we need to be working on addressing systemic issues in the criminal justice system in parallel to considering how gun violence is caused and creates harm in our communities. And focusing on broadening Second Amendment rights is ultimately going to be harmful to individuals who are experiencing violence, at the hands of the criminal justice system, at the hands of police, who will assume that if they have a gun, there's research about, and some other scholars have written about this, a Black person with a gun is assumed to be possessing it unlawfully with intention for violence, even if they have the proper legal, the permitting, the whatever's required under their state or city law. And so to just assume that expanded Second Amendment rights is going to make people safer in their communities is false. And so we need to be thinking about ways to address gun violence in communities most affected by it. That can be a combination of, community violence intervention type programs, investing in those communities because there's a strong connection between socioeconomic factors and gun violence in communities. Working towards a criminal justice system that provides equal protection, access to justice, when there is police violence that's experienced, and that's talking about qualified immunity. All of these things need to be happening in parallel, but to focus on broadening Second Amendment rights is ultimately, in my view, going to create more harm for individuals without actually changing the equities that we are trying to change in the criminal justice system. So that's sort of how I view the practical realities. And ultimately, I think with the sort of, empirics that I opened with about guns and how they make us less safe, I think the idea that people need to have guns to keep themselves safe is also a false premise. So all of those in combination sort of counsel reducing Second Amendment rights while in parallel working towards broadening other constitutional and social rights.
Mm-hmm. I guess the interesting, and no need to respond, but I'll just throw this out there, the reduction of Second Amendment rights, I suppose, and this is where the connection to Christopher's comments come in, doesn't necessarily mean the criminalization of the possession of a firearm, or do you think it necessarily leads to that?
No, no, absolutely not. And so I guess I will respond. I think that there are definitely non-carceral solutions to the gun violence epidemic. I think, community-based programs are one example. I think public education is another important example. So gun violence in this country was not studied for a long time because the CDC was not allowed to study it. And so as we start to get more information about the root causes of gun violence, different sort of factors that are associated with or correlated with gun violence, it's starting to give us more information about how to do that. But there's a lot of information out right now about how public education around guns can also help improve safety in communities. And obviously public education around how police interact with communities of color is an important piece of that to reduce violence. So there's a lot of different things that can be happening that are non-carceral solutions to gun violence, absolutely.
Yeah, and as I turn to Christopher, I'll just say that, I guess one of the difficulty, though, is in the context of federal litigation, it is a question of whether the criminal law is going to be upheld or not be upheld, right? So you don't have the panoply of possible solutions that you're pointing to. But on that score, Christopher, two questions. So the first is, it's first of all, just focusing on the brief that you wrote and submitted in Rahimi, challenging the dispossession of people that have civil domestic violence orders. It struck me that the main point that your office was making was really not a Second Amendment point so much as a due process point. And that is that you were claiming that it's problematic to take a civil domestic violence order as a proxy for criminal dangerousness, right? And if criminal dangerousness is a valid reason to take away somebody's firearms, I think what you're really suggesting is that civil domestic violence orders or that type of hearing doesn't necessarily implicate those facts. So I'm just curious if there was discussion around whether this needs to be framed as a Second Amendment claim or in the context of a Second Amendment claim, as opposed to just a broader point about domestic violence hearings and the types of fact-finding that needs to exist in those hearings. So that's my first question. The second question, you can answer these together or separately, is one of the things that struck me from listening to your comments and then listening to the comments of Amber, who followed you, was that the same groups that, or similar groups that are affected by the over-policing and over-criminalization are also the same groups that might have the most need for guns being out of their community, right? And so I guess the question, broadly stated, is how do we balance those two things, those two effects on the same community?
Right. So, quick housekeeping note, the Rahimi brief, I personally did participate in writing that brief, but my office did not participate in writing that brief. And all I am allowed to say is that I am not allowed to comment on Rahimi. But if you have any other questions regarding Rahimi, I strongly suggest that you pass those questions along to the Bronx Defenders and management and see what they have to say.
Fair enough.
But I will try to answer that while staying in those guidelines. So I guess kind of how I took that is is the Second Amendment the best avenue to address some of these concerns? And strictly answering that question, I guess I would have to say technically no, right? Because we were making in Bruin a race disparity argument. As we learn in law school, that probably falls more in line under a 14th Amendment or an equal protection analysis. But that was not the opportunity that was presented. So we saw the Second Amendment case, which had nothing to do with criminal gun possessions. We saw an opportunity and we went for it. And that's the reality of litigating when you are representing indigent folks, black and brown folks, right? Nobody's gonna knock on our door and say, hey, how's this gonna affect your clients? We gotta kick down that door and say what's happening, right? And there, from my understanding, I don't think that there has been a case that directly addressed the race disparities on point. And my clients that are getting sent upstate for 3 to 5, 5 to 15, sometimes even life, you know, they can't afford to wait for that opportunity to come. So that's why we decided to take this opportunity under the Second Amendment. I do think that certain principles that I've learned at my time doing criminal defense is very applicable here to answer the second part and some things that Esther brought up directly. Jails do not make us safer. Jails create a lot of the problems that we are addressing here, right? As a matter of fact, in my experience, jails create more of these problems than guns do. I think jails create more generational curses than guns do. Yes, I've seen a lot of violence in my job at the other end of a gun, right? Both by quote-unquote citizens and by police. I've been in the hospitals seeing clients shot by police and then charged with assaulting that police officer, right? I am not ignorant to that. And in a vacuum, trying to stop that gun violence, I do think that it's a noble pursuit. But the reality is that when we talk about strengthening gun laws in a vacuum, what I see in the courtroom is that being used as justification for more jail time and more prison time. There are times where defense attorneys and DAs reach a non-jail disposition on a gun case, and there are select few judges that say, no, I'm not accepting this. This person has this record. This person is charged with possessing a gun. It is not in the interest of justice to take this plea. Come back with something that includes jail time, right? And the justification that they use is some of the arguments that we're hearing here, that guns are dangerous, right? In arraignments, that's when we first pick up a case. The main question in arraignments is whether bail is going to be set. And after Mayor Adams got elected, it was almost the assumption that anyone facing a gun charge is going to have bail set on them, right? I just had an arraignment shift earlier in the week, I believe it was Wednesday, and I got 2 people out that were facing gun cases. And what my colleagues were saying was, wow, how did you do that, right? And, you know, that shows, like, you know, the fact that, like, it's a big win that somebody at arraignments before they even got convicted is now being confined to Rikers, probably for a year and a half while their case gets resolved. The fact that that's the standard, and then they say, no, we got to keep these neighborhoods safe. Neighborhoods which these judges don't even live in, and only come to work. And when they come and leave court, they're protected by a court officer, guess what, with a gun. And, you know, they're making all these decisions when on the other side of that incarceration, we're dealing with somebody with post-traumatic stress disorder. We're dealing with somebody that can't get a job. We're dealing with problems that are going to be handed down to generations beyond that client, right? The times that I do see clients that allegedly commit acts of violence, almost always comes down to 3 major things, which is poverty, addiction, or mental health, right? So if we're really concerned about the safety of the Bronx, which a lot of these judges really could care less, then let's start addressing some of these issues, right? Why is it that NYPD needs $11 billion when the Bronx still has the poorest congressional district in the country, right? If they were serious about addressing this, we would consider how many billions do we take away from the NYPD and put back in the hands of poor people in the Bronx. Let's be real. Nobody's talking about that. As a matter of fact, I do think it's important. Am I over?
Go ahead, finish your sentence.
Okay. I'll find another way to squeeze this in, but the incentive for judges that all but 3, I believe, in the Bronx are not elected, the incentive is to stay away from the sites of people with a lot of political clout, which is the NYPD and conservative newspapers like the New York Post. If they're too nice to my clients, they get thrown out of criminal court and into civil, or they just don't get reappointed altogether.
Okay, thank you. All right. So, last question. Do you want me to do that?
You have 1 more minute. I'm going to give you the 15 minutes.
Okay. Okay. Before I open it up to the audience, last set of questions for Amber, and it's sort of interesting hearing you speak both in your role as a prosecutor, as a state prosecutor, and then also as a community advocacy and policy expert. So let me start with the most interesting part of that for me, and that is, do those dual roles make you see Second Amendment regulation differently? Are they complementary? Like how do you view Second Amendment and gun laws based on those 2 roles? And then second, your work with community justice and identifying the root causes and effects of gun violence, does that help us reconcile Esther and Christopher's views? Does that help us chart a path forward?
Yeah, I mean, I would just say quickly on the kind of dual hats, it's really an honor because I get to working on community violence intervention with so many incredible people who, like, that are keeping our neighborhoods safe, that probably your mayor probably doesn't want to talk to, but that are keeping our communities safe, doing CVI, being on the front lines. They were also the people who were on the front lines of COVID whenever nobody was out in the streets trying to find people to actually keep people safe, to make sure that they had PPE and stuff like that. The first people that were the first line of defense in big cities like New York were community violence interrupters, and they kept our communities safe. And so I get to do that, and then I get to also wear that same hat whenever I'm in the district attorney's office. And I will just say my boss, the elected district attorney, twice duly elected a district attorney for Travis County, is a former federal prosecutor. So public defender. Don't tell him I said that. He's a former public defender, so he's actually never prosecuted a case, and he's the elected district attorney. And our first assistant was at the Bronx Defenders, and so she's also never prosecuted a case. But the cool part of that is not just like to say it, but our goal is to make sure that justice is done, and we truly believe that. I never wanted to be a prosecutor. I actually didn't even know what it was. I watched Law and Order SVU, but I did not know what a prosecutor was genuinely until I took the bar exam, which is kind of wild. So I was in my mid-40s when that happened. But I will just say, our goal is to make sure that people stay out of the criminal justice system, and that isn't like a fakie, right? Of like, okay, all we want to talk about is recidivism, because that's not enough to just make sure that people are not going to jail. What kind of resources do they have? Do they actually have access to jobs? Do they not have to contact the criminal legal system because maybe it will not protect them, right? So those are the types of things that we talk about in our office. And we also work on community violence intervention as these ecosystems that probably many of you have heard about. We are a part of the community violence ecosystem, but we play our role. We know that having a prosecutor sitting with someone who is helping to support community violence intervention, a credible messenger, is not going to be credible if he's sitting there with the prosecutor, right? But we do know that there's some information sharing that sometimes, not all times, but sometimes is helpful between our office and the community. And so we're in a really, really great, we're very honored to be where we work, but we also work with so many other organizations across the community. And so I'm really modeling this off of other places who have had successful interactions, but also really the district attorney's office, as my boss said last week at our gun violence summit, that there are ways in gun violence where we need to stay out of the way. And we need to play our role as a district attorney's office, and that doesn't mean being out in the front of some of the gun violence work as well.
Okay, so housekeeping, the second CLE password is sweet tea, 2 words. That was sweet tea. Okay, I could keep asking lots of questions, but let me stop for a second and open it up to the audience. Yeah, go ahead. I think so. Twanga, do you have a?
Hi, my name's Eitan. I'm a rising 2L at the University of Michigan. Wilhoit's law is the idea that conservatism means that laws are there to, that they're an in-group and an out-group, and laws are meant to protect the in-group but not bind them, and bind the out-group but not protect them. Under that, I think that we have allowed the right too much to co-opt the idea of the Second Amendment as to what is now post-2008. And when we say the expansion of Second Amendment rights is not actually, ironically, within the history and traditions of the Second Amendment itself. So is it not better to then talk about, until we get that back and take the ideas back, because the true meaning is people like March for Our Lives, and they are the actual defenders of the Second Amendment. Is it not better then to talk about our freedoms to live versus saying expansion of Second Amendment rights or things like that, or talking about these Second Amendment people, whereas that always puts us on the defensive there, and it's within their paradigm that we're still talking defensively, as opposed to offensively saying like what we're actually discussing is a freedom, our freedom to live. So thank you.
I think it depends on who. I think going back to probably what all of us have said, but I feel like I should have the freedom to not be shot when I'm walking down the street, right? But if I'm saying that versus, I think we still need the context of where we are in this country, because it is so embedded in this country to talk about the rights of bearing arms. So I think to your point, I think there has been more of an education on exactly what does that mean, what does it not mean, and what are the intersections? Because there's so many different intersections, whether we're talking about guns, we're talking about reproductive rights, there's a Second Amendment claim there too of like what our rights are, especially the right people have the right to give birth without getting shot, and there's a high rise of people who are getting shot while they're pregnant. And so I think that some of it is just context of who's the messenger in this country especially, but I think it's a great point, because I think that it should be the focus of like how we think even about litigation too, of like what are our rights, and we've thought a lot about, is there litigation around people not taking the public health approach to violence because we have the right to be living in a place that we have funding to have support for public health approaches to gun violence, and people aren't utilizing it. So yeah, I think there's a lot of different thoughts on the right to life too.
I'll just mention that there is some scholarship about folks thinking about litigation. The article that comes to mind is The Right Not to Be Shot. Yeah. I have thought about this in the context of litigation like Amber has, and it's a challenging case to bring sort of as a standalone concept, but I do think it's an important reframing of this issue. I think stand your ground laws are like an interesting test case for how it's been sort of like leveled up in terms of a right, where you have like this broader right to shoot people, and sort of how harmful sort of an expansion in that direction can be. And so if we see the harms of stand your ground, I think that that's like a test case for how we can see expansion of Second Amendment rights and why we need to be reframing it, and thinking about the person who's getting shot and not the person doing the shooting. Yeah, absolutely. Thanks for the question.
Yes, right.
Thank you so much. This was an incredible panel. I work in the reproductive justice framework, which focuses on the right to have children, the right not to have children, and the right to raise children in safe and equitable communities. And I've been thinking a lot during this panel about the intersections of RJ and gun violence, and I wanted to see if you could speak more to that. Specifically, Amber, you mentioned the right not to get shot when you're pregnant, the right to raise your children in safe communities, whether it's the threat of police brutality, the threat of violence within your communities, and the threat of school shootings, which to me is one of the first things I think of when I think of gun violence, even though I know it's not the reality of the only source of gun violence in our society. But I just kind of wanted to see if you could expand on that intersection.
I wrote a brief on this for law school. I'm happy to send it to you because I didn't even think about this intersection, but I learned about it from Black women who were not only fighting for Black women, but fighting for everyone's rights. And so I'm so glad that you said reproductive justice instead of just reproductive rights, because we're not just talking about access to abortions, we're talking about all rights and all justice for people that may be seeking abortion or just or women's health. And so, yeah, I mean, there's a lot of scholarship that's out there about the right, not only just pregnancy, but also the right to actually be able to seek pregnancy for pregnant people, and also the intersection of that and people not even be able to live long enough to actually get pregnant because they are living in a society that does not protect them. And looking at the intersections of like where people physically live, if you live in Chicago is very different than if you live in Austin, and what the birth rates are there, and also looking at the rates of what happens when people are actually pregnant and they witness the trauma of actually witnessing, not even having to see someone get shot, but actually hearing about someone in your neighborhood who's shot, is also a traumatic experience that also is, we have the right not to have that experience as well. So I'm happy to send and share it to you, but definitely great question.
I don't think this directly addresses what you brought up, but it does remind me of a question that I posed to a lot of people that critique our position or our brief. And I do think that a lot of sort of reasonable restrictions on Second Amendment grounds fails to answer the question of what happens when we want to bring other reasonable restrictions to other fundamental rights. And again, this is all stuff that I started thinking about not too long ago, but it seems like for a lot of people, restricting a fundamental right, which American law says it is, my ancestors had nothing to do with writing that Constitution, it says that it's a fundamental right. So, yeah, I want people to grapple with that. What does it mean if Black people shared a fundamental right in the Second Amendment, just like anyone else? And before we restrict other rights, I mean, abortion is not an avid example right now, but like the First Amendment, for example, some of these restrictions would never be thought of in a lot of these spaces for that right. So, yeah.
I'll just add, it is worth noting that something like a restraining order does affect lots of other rights that are, it's not just Second Amendment rights, right? So a restraining order affects your ability to speak to the person, right? It can affect rights over custody and raising of a child. It can affect private property rights, right? It can get you evicted from places. So just to note that the Second Amendment is not different. It's not exceptional in that certain things like a violence order, a civil restraining order might have effects across a number of fundamental rights. But your point is well taken. Just wanted to add that note. At the way back.
Yeah, hi. So I had a question about, I know during oral arguments with Rahimi, there was kind of a lot of debate around, we were talking about going to gun restrictions that were around at the time of the enactment of the Second Amendment. And I think one of the critiques that came up a lot was, at the time of the enactment of the Second Amendment, women did not have rights in any meaningful way, that, they were treated as property, that domestic violence was an accepted part of society, kind of considered like, the right of chastisement, that men had to abuse their wives. And I think, Esther, you mentioned the 19th Amendment in terms of how we interpret the Second Amendment, and it reminded me of Reva Siegel has talked about how the 19th Amendment should be incorporated in how we interpret other amendments, and I was wondering if you could expand on that point a little bit more.
Sure. I mean, I think that's sort of the fundamental point that I was trying to get at, is that if we read the Constitution starting and ending with the Bill of Rights, then we're missing a huge part of what our history and what our Constitution encompasses. And I think that Rahimi highlights the 19th Amendment as sort of this important touch point. I think it also calls attention to sort of the failings of the originalist methodology and this sort of backwards-looking approach. So when we talk about looking to history to understand the scope of a right without the future-looking context, so like, a couple hundred years later, women get the right to vote, we're missing a few different things. I think it's important to remember that the court today is still trying to view it through the lens of modern history. So when they're looking at this like collection of historical laws, they're still avoiding the ones that they call repugnant, right? And so they are coming at it with some context, but not explicit context on the way that the Constitution has evolved or the way that our society has evolved, just sort of in sort of like a gut check sense, I know it when I see it sense. And I think that this is problematic, one, because it continues to disenfranchise people who were historically disenfranchised, in that we're still not bringing them into the conversation of these historical laws. We're just cutting out ones where they were very aggressively, explicitly excluded or oppressed, but also because it fails to adhere to the originalist premise of these rights being sort of static and, either God ordained or sort of written in stone at some point in the past, and we're just sort of describing them today. Because our understanding of history is continually changing. It's hard to take information from historical silences, and if judges are the arbiters of what is repugnant today, then it is going to continue to evolve. And so our rights are not static in the way that originalists say, but they are gate-kept by originalists and originalist thinking. So it kind of like fails at every step. But I think it's so important that we view our constitutional rights in the scope of and it's not like the 19th Amendment is not an amendment in the way that the Second Amendment is an amendment. Like, these are all now part of our Constitution, so we need to view them as a whole. And Reva Siegel has some really great writing on this, so thanks for highlighting that.
Okay.
I know we have like 1 second. I was just going to say, I would also just, I obviously am not a Supreme Court justice, but I would also just, as we're having these conversations, also think about the 13th Amendment. And like, how, if we're going to talk about like what the impact of this as women not being a part of it, then we also need to talk about what the 13th Amendment meant, especially for Black people who were enslaved in this country too, and the historical nature of what the 13th Amendment did and hasn't still done to this day. So I just wanted to add that too.
You are not a Supreme Court justice to our great loss.
Not yet.
All right, so I know there are a couple hands up. I will bravely volunteer Esther and Christopher to stay after and answer all your questions in depth, but it is 4 o'clock, so we need to end. Please join me in thanking our panelists.